Plenary means unqualified or absolute. So, plenary powers are referring to the unqualified and absolute powers of the Parliament in certain situations on certain subject matters. The concept of plenary powers is not actually mentioned anywhere in the Constitution. It is actually based on the various judicial interpretations of the Constitution in various landmark cases like the Kesavananda Bharti case. Normally, the Parliament can make laws on the subjects in the central list, and the states can legislate on the subjects in the state list, and both can legislate on the subjects in the concurrent list. But in certain situations, such as a national security requirement or a defense requirement or due to an international relations requirement or in an emergency situation, the Parliament has the absolute and unqualified power to legislate on any and all subjects on any lists. Of course, thanks to the concept of checks and balances, the courts can still assess if the Parliament's actions are unreasonable, disproportionate or arbitrary, and the courts can still strike down the actions of the Parliament if required. In the Kesavananda Bharti case, the Parliament sought to amend the Constitution using the powers granted by Article 368. The court ruled that while the Parliament does have the power to amend any part of the Constitution, even with such absolute or plenary powers, the Parliament cannot alter the basic structure of the Constitution. So, even plenary powers have some limits.